All as if you have another sellout crowd, SRO, what will you do? Are they going to hang from the rafters?
Additional chairs are actually on their way, so thank you for your patience.
Well, welcome. This is our fourth symposium on ethics across the profession, and I'm Elizabeth Rindskopf Parker. I have the good fortune of being the dean at Pacific McGeorge, and Paul Paton, who is really the intellectual and the organizational force behind this, always gives me a moment just to say welcome and hello, but he does that taking his, what shall we say, program in his hands, because he knows that when I stand in front of a microphone and I have an opportunity to talk about this particular subject, I may go on. I promise not to go on too long, but albeit we're going to be in a few minutes talking about some things that have great weight and really tremendous importance, I thought I would begin on a lighter note and just tell you why this is always such a fun opportunity for me. You know, Justice Kennedy, who is one of our, how shall I put this, longest serving faculty members, has commented that it's all right if you stumble into the truth. And I stumbled into the truth here. This symposium began as a luncheon conversation a number of years ago with Len McCandless at the Sierra Health Foundation, and I want to thank them for their support, which makes it possible. We wanted to do something in ethics, but you can see the problem immediately. We're a law school, and they're a health foundation. What was to be done? And so as we talked about this, we came upon the notion that maybe we should do an ethics symposium that would go across all professions. And indeed, that's what we came up with. We didn't know whether any faculty member would think we were wise or foolish or run screaming from the room. And the good news is that it hasn't been just Paul, but George Harris before him who embraced this warmly. And we learned in our very first symposium, where Deborah Rohde was our featured speaker from Stanford, that indeed Stanford had already figured out that this is really a very important approach to ethics. And so, Paul, I'm delighted that you have been the second director, and I can only tell you how effective he's been at it. You've taken what was an idea over lunch, not with wine, and you've deepened it and you've made it meaningful. And so I very much thank you, and of course I've mentioned Sierra Health, but I also want to just say one quick word to the Capital Center for Public Law and Policy. They really do create the context and the structure where these kinds of things happen. And so Leslie Jacobs is here somewhere. There she is. She's our director. She has given this all of her support, and when Leslie gives support, you know it's going to happen. And so Leslie, thank you and your center. And then finally, we've co-ventured this particular activity with the World Affairs Council of Sacramento, where we are the home to that chapter. And we did so because it is across the professions. We hope to draw in both, of course, our legal colleagues, both in practice and in academia, but importantly, we want to broaden our reach to the community, because ethics is indeed, as you all know, permeating all of our thinking about so many different aspects of our society today. And so with that, I'll simply thank you as obviously a wonderful and engaged audience, and turn it over to Paul for a formal introduction.
Thank you very much indeed, Elizabeth, and for your kind words and your continuing and very important support for ethics initiatives, both in terms of the Ethics Across the Professions initiative, ethics education at McGeorge for alumni and beyond. Judges, distinguished professors, friends, students, faculty members, welcome to the fourth Ethics Across the Professions Symposium. When I began thinking about topics last year, little did I know the letter that came out, and some of you may have heard about this already, would arrive today from the Supreme Court of the United States letterhead. This was released about an hour ago. Indulge me while I read it to you. Chambers of Justice John Paul Stevens, April 9th, 2010. My dear Mr. President, having concluded it would be in the best interest of the court to have my successor appointed and confirmed well in advance of the commencement of the court's next term, I shall retire from regular active service as an Associate Justice under the provisions of 28 U.S.C. 371B, effective the next day after the court rises for the summer recess this year. Most respectfully yours, signed John Paul Stevens. An hour ago. And so it actually puts into much more stark focus for us the topics we're going to be talking about today. And let me just give you a preview and overview of the conception of the day and the richness of the dialogue that we're going to be engaging in. Questions of judicial ethics and accountability have bedeviled people in the United States, in Canada, elsewhere in the world, as we try and sort out the balance between transparency and accountability, what we expect of our judges, and how we uphold the rule of law. We had a very visible demonstration of that a couple falls ago in Pakistan, when lawyers actually went out and took to the streets in the defense of the rule of law. And one of our local judges, Morrison Forster, met with the Pakistani High Court judges last fall and talked with them about that experience. A very visible and poignant demonstration of the importance to lawyers of judicial ethics, accountability, transparency. We're all invested in the system as lawyers, as members of our communities, as judges, as those responsible for making important decisions about liberty interests, about political questions, about all of these other issues. And so what does it mean to be an ethical judge takes on that much more importance when people are looking at it. And so in terms of today's and tomorrow's discussions, we go from domestic to international and try and touch on at least some of these issues. Our first panel, which I'll come back to introducing directly in a moment, will tackle some of the big picture thinking, the questions around what it means to be an ethical judge, and what is it that we know about implicit as well as explicit bias, and how do we deal with this. And I apologize for those, we're a slightly overfilled room to expectations. I know that more chairs are on their way, so thank you for your patience. What does it mean to have implicit bias, and what do we do about it? From there, directly into a very deep discussion with experts on questions that have faced the U.S. Supreme Court and other courts about judicial elections, campaign financing, and taking some of the issues around the codes of conduct and bias and trying to discern exactly how the United States is going to approach these questions. From that, the national to the international briefly over lunch, we're privileged to have Justice John Hedigan from the High Court of Ireland addressing us about 47 different traditions, one court. How do you actually bring all of these judges from these different legal traditions together and have ethics and accountability in a manner that's meaningful? Then back home to the California Commission for Impartial Courts, 71 recommendations about how to actually implement some of these ideas, and a discussion about what those issues, ideas, questions, and problems are. And then finally, at the end of the afternoon, judges, media, and, in brackets, incivility. What goes on in courts? What responsibility do lawyers have for civil conduct? What responsibility do judges have for civil conduct, and what can we do about it? Tomorrow morning moves from domestic to international, a review of codes of conduct, and we'll have joining us by video conference the chairman of the ABA's Commission for the Model Code of Judicial Conduct, who was very directly involved in the crafting of at least that document. Sarah Craven's doing a survey of codes, domestic and international, and a discussion about implementing that in one illustration in Kosovo, where Americans in the American Bar Association and Jim Moliterno has been very directly involved. And then it's a real privilege to have both Judge Hedigan, Judge Fausto Pocar of the International Criminal Tribunal from the former Yugoslavia, and Lee Swigert talking about international judging. And so in alignment with McGeorge's focus both on the domestic and the international, the American Bar Association's Ethics 2020 focus on both technology and globalization and its impact on the profession, we're touching a lot of bases in a day and a half. We have a very rich program, and it's going to be even further enriched by your participation, and I hope that you will feel free, students, judges, faculty, and others, to participate and contribute as you will, and the moderators are primed to ensure that you have an opportunity to ask your questions and speak. So with no further ado, welcome, and let me introduce our first panel. And what a way to start. Judge John Irwin is the Chief Judge of the Nebraska Court of Appeals, served through September 2004, was elected President of the National Council of Chief Judges of the State Courts of Appeal in 2004, has served on a number of commissions and committees dealing with issues of judicial ethics, minority justice, adult justice, juvenile justice systems, access to justice, and the reform of the legal profession. Since 2008, he's been a faculty fellow for the University of Nebraska Public Policy Center, involved in research and scholarship on projects relating to law and judicial systems, and it was a wonderful chance to engage, actually, as we were planning this panel, with Judge Irwin's outreach, bringing in people from Harvard, from UCLA, from other experts or institutions around the country who are known to him who he wants to get involved deeper in these issues. We're also privileged to have his clerk, Dan Rael, with us this morning. Thank you, Dan, very much for your contribution to the discussion, to the paper that you've got in the materials, and all of the papers that have come in draft are in the packets of materials that you have with you. So Judge Irwin, welcome. Very proud to have Richard Devlin, University Research Professor at Dalhousie University Schulich School of Law in Canada, the new label and branding for Dal. A colleague and a friend from Canada. You will detect throughout the day occasionally that my accent slips in. I am indeed one of them, not like the new characters in those of you who watch the ABC program V. I don't shed a skin at any point, but underneath it all, like Celine Dion, I am amongst you, at least temporarily. So Richard is University Research Professor and a real expert on perspectives on legal theory, critical disability theory, lawyers' ethics, professional regulation, and has spoken and talked widely on both lawyers' ethics and judicial ethics, and is doing some very interesting work with the National Judicial Institute in Canada. So we'll get an inside-outside perspective. And then finally on this panel, Brad Wendell, who is Professor of Law at Cornell Law School, has been at Cornell since 2004, had a real difficulty during the NCAA basketball tournament with both the Cornell run and the fact that he's a graduate of Duke.
There was no difficulty. Duke was there. Right.
Brad is probably, amongst a group of us who are legal ethics scholars, researchers, teachers, considered a leading light in terms of legal theory and legal approaches, and I've always found his writing, his teaching, and his contributions to be most thoughtful and provocative in that respect. And so it's a real privilege, Brad, to have you here to comment on both of the other papers. I've set the stage. We've got Justice Stevens' letter to reflect on, and I'm hoping that the panelists will pick up on that and some of their commentary on what will end up coming next as the day progresses. But let me offer you again my most sincere welcome and thanks for participating in this. And Judge Irwin, let me turn it to you.
Thank you.
Well, good morning. It's quite an eclectic group of attendees. I wasn't sure what the audience would be. My remarks are focused at the judicial mind and people interested in the judicial mind, so maybe you can all be judges today. So good morning, Your Honors. Our legal system is built on the judicial bedrock of impartiality. Are judges impartial when making their decisions? Judges grapple with bias as an intellectual concept, but also on a day-to-day basis as a practical matter when we're making our decisions. Now, how do we make our decisions? These decisions that have extraordinary impact affecting people and institutions, does unconscious bias prejudice or manipulate our decision-making without our knowledge? I think this question deserves reflection and discussion today in this program, and I'd ask you to keep, pardon me, I've had a cold for some time, to keep these thoughts in mind as you move through all the programs. I think they seep into all the programs that we'll be listening to over the next day and a half. Yale psychologist David Armour, along with a lot of other social scientists, believes that when judges make decisions, we are deluded by what we call the illusion of objectivity. And that's the notion that we are free of the very biases that we're so readily anxious to see in other people and that we can identify in others. What's more, these unconscious or implicit biases, and I use the terms interchangeably, can be contrary to our consciously held beliefs. Consciously, we probably, with confidence and conviction, don't believe that a person's race, gender, height, weight, teeth, whatever, affect our decisions. Or we think that somehow we're immune from the myriad of associations that we have, these unconscious forces, and do they play any part in our decision making as judges? I'd like to thank Paul for his very kind remarks. I come here today as a Court of Appeals judge for 18 years. I've been a lawyer for 33 years. I am the former chair of a judicial ethics committee for the state. I'm the past president of the National Council of Chief Judges. And I say those things primarily just to give you an idea that I have had tremendous opportunities to speak with judges across this country and to have a real sense, I think, of what goes on, what judges think, and how we operate as judges. But most importantly, I feel I stand here today as a person who over the last few years has been trying to make a conscious effort to learn how to, as a judge, make better decisions, keeping in mind the dynamics of how we go about making our decisions. The notion of implicit bias, unconscious bias, you don't have to accept it. I'm not here to proselytize, or I have nothing to sell. But for the sake of a thoughtful intellectual discussion, what if unconscious bias really does exist? What does it mean to us? What does it mean to judges who have an ethical commitment? Our code requires it, that we make our decisions impartially, we make them objectively. And to internalize, truly internalize what that means as we make decisions. Many social scientists now are concluding that these unconscious social biases do exist, and in fact, they feel that these unconscious or implicit biases may in fact warrant some skepticism towards how the judicial system operates vis-a-vis judges making decisions. One of the social scientists that I'm most familiar with, and maybe you are as well, her name is Dr. Mahzarin Banaji. She's at Harvard. She's the, if I can get this right, she's the Cabot Professor of Social Ethics and Psychology. And she's presented a lot about this notion of implicit ethics, and I've had the opportunity to work some with her over the last couple years. You might know her, some of you, as she is one of the creators, one of the, I'll just leave it as designer, creator, along with other social scientists, of the implicit assessment test. It's known as the IAT test. You can go online, you can take it, and you simply put in IAT into Google, it'll pop up and you can take it. But what is it? Well, the IAT, if I can just use that shorthand expression, it's a test that's based on the belief that we operate as human beings in our decision-making process on two levels. The first is the conscious level we all think of, very deliberate. I chose to wear this suit today. I chose to read the book last night before I went to bed. Those are conscious decisions we're consciously aware of. But what I'm here to ask you to consider is the second level, the unconscious level. And these social scientists, and I certainly believe there is some, at least some, merit to what they're saying, is that these unconscious, implicit thoughts do impact how we behave, think, feel, and make decisions. And it's also this second level that may be important in discriminating, stereotyping. I don't think anyone in this room would ever believe that you consciously stereotype or discriminate. I would guess no one does. But that's not the point. The point is, do we have unconscious stereotypes, thoughts, that do affect our decision-making and our processing? What I'd like to do is just show you a brief video. It will show you the IAT test, how it works. You can go take it if you want afterwards, that's fine. There's been, I believe, over 10 million tests taken. It's been going on since 1990. It's all data-driven. But it's an interesting test, just one of the things I wanted to point out to you. So if you just give me 1 second, this all works, I hope.
Hello, and welcome to Scientific American Frontiers. I'm Alan Alden. We all like to think that we understand our own minds, that we carefully weigh the pros and cons when we make a decision, and that after we've made it, even if we have cause to regret it, we know why we decided the way we did. Well, sure, we know some choices are more emotional than rational, but even then, we think we're conscious of all the conflicting arguments that run through our minds as we make choice. Well, in this program, we'll find out how utterly deluded we are as we join in experiments revealing just how sneaky and underhanded our brains can be. I've always thought of myself as a feminist, so I'm pretty sure I know how I'll do in this test of my reaction to women in the workplace. I'm ready to begin. Women, in fact, like Mazarin Banerjee, who's a professor here at Harvard University. The test is called the Implicit Association test, and it begins simply enough. I have to pair the word in the center with one of the words above by pressing the E key with my left hand or the I key with my right. Well, I like to be either way. Mazarin has told me to do this as fast as I can because it's the time I take to make the associations that's critical to the test. Now the target words have changed, but the task remains the same. To quickly decide whether the new words belong to the left or the right. But things are about to get trickier.
It's the same thing, except now any one of these four will show up, but when it's career or male, you'll press the left key. When it's family or female, you'll press the right key.
Career or male.
Yes.
So now the categories are described by two words, making it harder to decide where the new words belong. But since historically male and career have gone together, this is like reinforcing the stereotype.
That's exactly.
The point of the test is to discover if lurking beneath my feminist convictions, I actually harbor a hidden bias against women in the workplace, based on all the associations between man and career, women and family, that bathe the culture I grew up in.
Now just
Male,
right.
female, okay, now you're testing. The implicit association test is designed to ferret out any bias by seeing if it takes me fractionally longer to figure out where a word belongs when the pairing of the target words, in this case family and male together and career and female, is slightly more difficult for my brain to accept. Corporation, family, brother, management, you were done.
It's like, I could tell, it's like, this is very good. So let's see, you're showing a slight automatic association between male and career, and only 12% of the population that takes this test shows this bias. What you're seeing is that you're showing a much smaller bias than what many other people show. I'm up here. I make a strong association between male and career and female and family, even though that's not what I consciously express.
That's not what you live.
And that's not where I live, but in my world. And I don't know, I'd be interested to know, maybe many years of working in feminist causes make you show this lesson.
So all those years of working in feminist causes didn't manage to totally eliminate my lingering association between female and family, and male and career. What's astonishing, though, is that Mazarin is far worse, and she's not only enjoying a very successful career, she designed the test. Another of its designers is Brian Nozick, who personally developed.
As you might guess, the IAT is not without its critics. I think that's the nature of science. The IAT does show consistently, whatever value, weight, gravitas you want to ascribe to it, it is showing that there are biases that the test takers are not aware of consciously. Test takers just like you and me. What's important to remember is that doesn't mean that we are consciously biased people, or that we should accept these biases and just move on. We don't agree with these biases, but what about, is there anything to gain by accepting the possibility that this phenomena does exist as far as decision making? I would ask you, with all due respect, to consider taking the opportunity maybe to make even better decisions, all you judges out there. The decisions that impact people, impact institutions profoundly. Making decisions that maybe will improve the legal system even more by better decision making. And without sounding too corny, I think as judges, we all love the institution of the legal system, and that's why we're all here. Let me ask you all this, though, if I may. How objective are you? Don't answer. Are you 100% objective when you make decisions? You saw some of the pictures of possible stereotypes that I just pulled off the internet. Are you 80% objective? Well, objectivity appears to be one of those redeeming traits that we all think we possess, and we're just convinced of it, which is really kind of peculiar given how much fighting, arguing, conflict goes on at both the micro and macro level in society and in the world. Nobody ever thinks they're closed-minded. That's the illusion of objectivity. And I submit to you that people who are consciously impartial, who champion principles of equality and fairness, that they are just as likely, and maybe even more likely, to be drawn into unconscious prejudice. Prejudice that conflicts with their conscious values. Are we flexible? Oh, of course we are. Do we appreciate different lifestyles? We all say we do, and I think we try consciously to. No one would ever discriminate based on race, gender, age, anything like that. But allow me to ask you to just do this. Engage in this exercise. Close your eyes, and you can literally close them. But whether you do or not, think about the people who you spend most of your time with. Just picture them. Do they look like you? Same age? Same race, same likes, same dislikes? Did they go to the same schools, belong to the same types of clubs, organizations that we do? How do you feel? Ask yourself, how do you feel and how do you react when a person who holds a belief different than yours questions you? How do you react to that? Have you just, over the course of our lives, pardon me, have we developed filters or patterns that have served us very well, got us all here to this point, but that we feel uncomfortable changing those patterns and filters? Do you go outside your comfort zone? Do you occasionally reevaluate yourself and say, am I really too comfortable? Could I be better? Could I grow? My guess is that few of us ever wake up, or go to bed at night, rather, I guess I'd say, and say, was I thinking right today? I don't think we do that. Or if we do, we can certainly do it more. We simply carry on as we have before, especially as judges. We get reelected, we get retained, we get our paychecks, we don't have grievances filed against us, and sometimes that's what it seems like it's all about. And let's put it a different way. I think one of the biggest hurdles to overcome for adults is to think differently. And why it's so difficult is really easy to understand. We've all perfected these decision-making processes that I've referred to. And to go radically outside that comfort zone, to go radically away from those processes that we've honed and developed and built over years, if we get away from those, we'd need a map and a compass to get back. It's very uncomfortable. And also, as adults, and I think the older we get, the more we go through these processes we've learned, we actually believe that our view of reality is reality, that it is in fact the reality. Well, what's the solution here? I don't have a solution, I just have some suggestions. And I couch it in terms of vigilance. That is eternal vigilance, the notion that we as judges are leaders of institutions, that we, at its heart, vigilance is a conscious awareness of wanting to change in this situation. Consciousness has maybe 4 main components to it: awareness, control, intention, and self-reflection. Just maybe we should think about those. We need to try to go down different paths and explore more. For example, can I say to myself, when I now make a decision after today, that I'm going to consciously try and make that decision in light of what I've heard here today. Not the same old way, same pattern, same methodology that we've used in the past to make our decisions. Observe, interact with new people, new foods, new music. It's just anything to break out of those comfort zones. As judges, we are empowered, I would almost say endowed, with power and responsibility to create, to make impartial decisions in real time, in real life, with people who are impacted, real people who are impacted. And we have to constantly go to the limit as judges to struggle to keep making impartial decisions. Well, they'll never be totally objective, but to keep improving our decision-making process. Albert Einstein said, you cannot solve a problem with the same thinking that created it. Objectivity really will persist as mostly an illusion for all of us if we don't have a commitment to rethinking. And that's what I ask you to do today, and to try out to exercise it. To rethink whether biases linger inside of us, and rethinking because it's the right thing to do, not because someone's checking up on us. I think judges want to do the right thing, and they try and do the right thing and behave in what I call a virtuous manner because of the respect we have for this system. So I would ask you today just to make a commitment, a small commitment, to rethinking how you make the decisions in your life, how you conduct your life, and think if maybe there is value to be gained in decision making and in fact your whole life by that commitment to making objectivity a reality and not an illusion. So, thank you very much.
So now I think we need the technology to shift to my PowerPoint presentation. I think there's a person in the back room. There he is. Maybe while we're setting up here, I'll make a couple of introductory comments. And first of all, I do think that I want to thank the Capital Center for Public Law and Policy here at McGeorge, and especially Professor Paul Paton, for inviting me to participate in this energizing and exciting comparative conference. Judge Irwin and Professor Wendell are obviously the voices from home on this particular panel. I'm the voice from away, the voice from abroad. And probably by the end of my talk, you'll think the slightly crazy Canadian voice. And I'm actually very comfortable with being seen to be the outsider, the person from away, because although I'm from Canada, I'm actually not really from Canada. I'm actually from Ireland, as my accent probably betrays. So if you do think I'm crazy, please don't blame the Canadians, right? Blame the Irish, right? They get blamed for a lot of things. So my talk today is called Reconstructing Judicial Ethics in Canada. And we've been asked to address several key questions. What does it mean for a judge to be ethical? How should judges overcome implicit or explicit bias? John's clearly talked about that now. Does appointment to the bench mean leaving personal, professional, moral, or political identity behind? Why did Judge Sotomayor's comments about her own identity and experience attract such attention and controversy? And can judicial ethics be taught? Now, these are all clearly very complex, challenging questions that will take a lot more than the 20-odd minutes any of us have allocated to us. I'm going to try to answer these in an indirect way by talking about the status of judicial ethics in Canada. I will proceed in 4 stages. First of all, I'll lay the foundations by talking about the history of ethics in Canada. Secondly, I'll talk about several recent institutional initiatives. Thirdly, I'll make a couple of suggestions as to where I think we should go in Canada, and perhaps also in the United States, in order to reimagine and reconstruct judicial ethics. And fourthly, I'll come back and answer these 5 questions quite briefly, and conclude with what might be seen to be the iconoclastic claim that we need to give up on the search for what I'm going to call the false god of impartiality, and instead seek a different goal, which is to seek to minimize partiality. And I'll try and elaborate those ideas as I unfold my talk. The first thing I want to do is to lay the foundations of ethics in Canada. Unlike the United States, where there is a well-developed regime of judicial ethics, in Canada there has been a relative dearth of analysis. Historically, the topic of judicial ethics has been seriously underdeveloped. Judges, as paragons of independence and impartiality, were, by definition, impartial. Indeed, it was only in 1980 that the Canadian Judicial Council sponsored what was called a book for judges, and a comparison French text called Le Livre du Magistrat. The author of the first book, I think, rather quaintly characterized his book as, quote unquote, friendly advice from experienced judges to brother judges. Right? It was a moment of its time, but it still carries the same resonance today. The major point I want to start off by identifying is that in Canada at the moment, in 2010, we still do not have a code of conduct for Canadian judges. Rather, what we have is a nice, very elegant, well-produced pamphlet, or little booklet, published in 1998 called Ethical Principles for Judges. The important thing about this particular document is that it makes it very clear that the statements, principles, commentaries are advisory in nature. The goals are to assist judges with the difficult ethical and professional issues which confront them, and to assist members of the public to better understand the judicial role. But this is the kicker. They are not and shall not be used as a code or a list of prohibited behaviours. They do not set out standards defining judicial misconduct. This is important because Canadian judges have developed 4 arguments to resist the creation of a code. They argue, A, it's unnecessary because they're so virtuous, and they explicitly indicate, unlike many elected American judges. Right. Secondly, they claim the codes of conduct pose a threat to judicial independence and partiality. They say it misconceives the essential function of ethics, which are aspirational, not prescriptive. And they also claim that a code cannot be comprehensive, therefore we shouldn't have one. Anyways, the critics tend to argue, give me a break, right? How can you have a legitimate regime of judicial self-regulation if you haven't articulated what the standards are? It just doesn't work. This debate came to the fore in Canada quite recently in a case called Matlow, in which Mr. Justice Matlow became highly involved in a local community group which was opposing a development of the Toronto Transport Commission. The evidence in this case established that Mr. Justice Matlow organised and led the local group. He contacted municipal and provincial politicians, including the Attorney General, to complain about the Toronto Transit Commission. He approached newspaper columnists, encouraged them to write articles critical of this project. He used quote-unquote intemperate language in this context. Many of his communications used the language of being a justice of the General Division of the Supreme Court of Ontario. And finally, that he also sat on another case dealing with the TCC, which was dealing with another development project in which he ruled against the development project. A 5-person board of inquiry determined that his behaviour was, quote-unquote, manifestly and totally contrary to the impartiality, integrity and independence of the judiciary. They recommended he be removed from the bench. The majority of the ultimate Canadian Judicial Council, however, decided by 17-4 that yes, his conduct was judicial misconduct. However, they did not recommend removal from the bench. Instead, they suggested 3 penalties. 1, compulsory participation in a judicial ethics seminar. 2, the drafting of letters of apology to members of the TTC. And 3, that if he was to engage in any further public activities, he would have to get the approval of a committee of other judges. The minority, however, thought that his conduct was deeply problematic, that it would undermine the public confidence in the administration of justice, and they recommended his removal. The key point I want to make here is central to Justice Matlow's defence and the majority decision was the claim that these ethical principles that I just put up a few minutes ago, right, quote unquote, are not written as prescriptive conduct and is not possible to apply them as such. So, in sum, critics argue, to lay the foundations, that the Canadian Judicial Council has not gone far enough in its regulatory obligations. Of course, judicial independence is important, but so too are accountability and transparency. An enforceable code of conduct would enable the Canadian Judicial Council to walk the walk, not just talk the talk. So if I move to the second part of my presentation, I want to talk about framing it up. What has happened recently in Canada? Now, we've done a couple of things in Canada, and I don't have time to go into all of them, but I want to talk about a key initiative around judicial education programs. We have determined in Canada that it's very important to focus on judicial education. And we've tried to think about judicial ethics in two lights. The first is to create what we've called judicial ethics modules for Canadian judges. These can be half-day programs, 3-day programs. The centerpiece of these programs are what's called a framework of ethical analysis. And this framework of ethical analysis is given to judges, and then they're meant to think through and deploy this analysis to a number of scenarios that we work through what we call adult learning principles. The framework we've developed, that has been developed initially, had several issues. What's the ethical dilemma? Are there specific legal rules or established principles of ethical conduct that are relevant to the dilemma? If relevant, if this was an in-court problem, what's preferred course of conduct by counsel or litigants? What steps would you take prior to identifying your options? In the light of the events as they occurred in this fact situation, what are the permissible options and choices? And then finally, if possible, identify your preferred choice or option that, in your opinion, most closely accords with the rules and principles identified in number 2. And you'll find this all in the paper that's circulated. Now, I'm going to come back and talk about this framework because I think it's got some strengths but some weaknesses a little bit later. But secondly, and perhaps more controversially in Canada, we develop what are called social context education programs. And these come at exactly the problem John was speaking about a few minutes ago. We've been developing in Canada social context education programs that have 3 particular functions. To assist judges to gain better understandings of the communities they serve, the impacts of disadvantage, and particular social, cultural, and linguistic issues that shape the persons who appear before them. The second is to assist judges to examine their own assumptions, perspectives, and views of the world. And the third is to explore the impact of contextual inquiry on issues related to judicial role, judicial process, and the process of judgment. Now, I want to emphasize this discussion around social context education because many people believe that social context education is a threat to the first principle of judicial ethics, which is impartiality. Traditionally, impartiality has tended to be conflated with the ideology of sameness of treatment. This correlation of impartiality with sameness is premised upon, I believe, a formal conception of equality. In Canada, and this is unlike the United States, our ethical principles, which I mentioned earlier, explicitly do incorporate an equality principle. It says judges should conduct themselves and proceedings before them to assure equality according to law. Our lodestar in Canada tends to be more equality than liberty. And this is played out in our commentaries. I'm not going to go through them all in detail, but some of them include the Constitution and a variety of statutes enshrine a strong commitment to equality before and under the law and equal protection and equal benefit of the law without discrimination. This is not a commitment to identical treatment, but rather to the equal worth and human dignity of all persons, and a desire to rectify and prevent discrimination against particular groups suffering social, political, and legal disadvantage in our society. We continue toward the last line here. The law's strong commitment, societal commitment, places concern for equality at the core of justice according to law. A few lines later, we talk about equality according to law is not only fundamental to justice, but is strongly linked to judicial impartiality. A little bit later, we play it out a little further, and I'll come to the last one. Judges, therefore, should attempt by appropriate means to remain informed about changing attitudes and values and to take advantage of suitable educational opportunities, which ought to be made reasonably available, that will assist them to be and appear to be impartial. Now, throughout the 1990s and early 2000s, about 1,000 of Canada's 2,000 judges enrolled in these social context education programs. And we covered a wide range of areas: public law, private law, substantive law, procedural law. And we dealt with a large number of issues: race, gender, sexual orientation, disability, poverty, self-represented litigants, linguistic disability, those sorts of issues. Now, sometimes, as I've said, this is seen to be decidedly controversial, a threat to judicial independence and impartiality. But in Canada, we have developed, the Supreme Court has developed, a number of what we call unwritten constitutional values. These include commitments to federalism, democracy, constitution and rule of law, all of which are sort of unchallengeable. But they've also talked about respect for minorities, respect for the inherent dignity of the human person, commitment to social justice and equality, accommodation of a wide variety of beliefs, and respect for cultural and group identity. And it's that particular group that I want to focus on. The final one is faith in social and political institutions, which enhance the participation of individuals and groups in society. My point in highlighting these unwritten constitutional values is to suggest that these provide what I want to describe as a sort of ethical grundnorm for Canadian judges. There is a danger that individual judges will engage in subjective preferences. What Canada's constitutional principles do is provide an orientation and foundation for the pursuit of judicial impartiality. In the American context, Brad Wendell, for example, has discussed how the idea of fidelity to law can define the role and morality of lawyers. What I want to suggest in the Canadian context is that these unwritten values, or in fact our constitutional values, both written and unwritten, help define the role and morality of judges. In short, social context education cannot be legitimately criticised as a threat to judicial independence or impartiality. On the contrary, because it enhances the capabilities of judges to deploy Canada's deeper constitutional values. These are values of respect, of substantive equality, not just formal equality, and social justice, that ultimately enhances judicial independence and it enhances judicial impartiality. And it develops what I want to call the ethical identity of our judges. So this leads me to the third part of what I want to say, which I want to talk about: how do we actually reconstruct the ethics edifice for judges? It's clear that I think that there's been problems with the Canadian ethical program. We have been making some significant progress, but I want to suggest that we need to go further. And I want to suggest two key ideas. The first key idea is to go back to the framework of ethical analysis that was developed by the NJI initially. I think this is a useful framework for judges to think through, but I don't think it goes far enough. The reason why I don't think it goes far enough is it still works within a formalistic paradigm of reasoning, i.e., find the rules, apply the facts to the case. It's pretty much a Langdellian view of the world. But legal reasoning is different from ethical reasoning. In my experience of working with Canadian judges for more than 20 years, they tend to be somewhat formalistic. It's not their fault, it's how they've been educated. The problem is it doesn't teach them how to think ethically as opposed to legally. So I want to modify this particular proposal by adding several more layers of analysis. Building on parts 1 and 2, I want to suggest that judges identify the underlying philosophy and spirit of the rules or principles. I want to suggest a little bit later that they try to ascertain not just the rights of the parties, but also the interests, wishes, rights, and rights of all potential parties. I think that the judges need to learn how to consider these larger constitutional values that I've just talked about a few minutes ago. I'm also uncontroversially putting in here the suggestion that judges must consider and identify their own personal values. And I've got 5 minutes left, and I can do this in less than 5 minutes. Judges can't do this in less than 5 minutes, by the way, right? Which is part of the point, right? It's also important that judges learn how to think more like ethical thinkers. They have to think about the short and long-term benefits, the harms, the means, the ends. They have to be able to engage in discussion with others if appropriate, because ethical decision making is a very deliberative process, more deliberative, I think, than legal reasoning. We have to think about the scope of one's discretion. And then after judges have engaged in what I call situated self-reflection, they have to identify their priorities, make their choices, and then after the choice has been made, to review the results and the processes, and then develop institutional mechanisms for future situations. So this is my first major reform suggestion. We need to develop the skills of ethical reasoning as opposed to legal reasoning. The second key initiative I've been arguing for is to develop what I want to call a larger judicial imagination. A couple of years ago in 2008, the National Judicial Institute in Canada decided to develop what it calls a sophomore program. This is a program designed to last 5 days in which judges who've been sitting for about 5 years go away for an intensive retreat. And the focus is twofold. It's to help judges reflect on the challenges, stresses, and successes of their first 5 years as a judge. But then secondly, and more importantly, to assist them to develop capabilities to move forward for the next decade or more of their career. Now, as they were designing this program, they asked me would I help them sort of participate in this project. And I suggested yes, but I want judges to think about what I call both an role morality and an ethical identity. And to achieve this, I suggested we need to move beyond what we're comfortable with. And I suggested, as a proposal, that we need to look to another profession to see the ethical challenges of another profession. And I think this fits quite nicely with the theme of McGeorge, which is ethics across the profession. And so what I suggest is if we look at something that's unfamiliar, the challenges that architects face, and bring them back to judges, we can see the familiar in a new and different light. And so what I've done in the Canadian context is develop the concept of what I want to call judicial architects. And briefly I'll identify 5 themes and then wrap up my thoughts. The first thing that architects must do is think about the integration of function, structure, and beauty. The second is to establish a balance between the technical and the practical, with the conceptual and the visionary. The third is to calibrate the continuity and change to provide cohesion between the past, the present, and the future. The fourth is to be responsive to both the individual and the larger community. And the fifth is the quest for the infinite within the finite. And in that project, I analogize a series of judicial challenges to these architectural challenges. And I suggest that there's a new and better way about thinking how to be a judge. We ran this program for the first time last year in Canada, and it worked extremely well. We have, however, decided to redo it this year and modify it. This year, what we're going to do, I'm going to develop this framework, and I'm going to be accompanied by 2 Canadian judges who will take each of these ideas and talk about cases they've been involved with, or situations which they've been involved with, which identify these challenges for the judges. So the ambition here is large. It's different. It's trying to get beyond that which we are comfortable with. It's to really help judges develop a conception of having, not just being a judge, but having an ethical identity as a judge. So to take these ideas that I've just mapped out and map them on to the first questions we were asked, what does it mean for a judge to be ethical? My answer is, it means to have a well-considered and developed ethical identity to become a judicial architect. How should judges overcome implicit or explicit bias? I think by developing a sophisticated framework of ethical analysis so that they can more readily identify potential biases. And here's my iconoclastic point. My view is that it's actually not possible to achieve impartiality. It's just not within the realm of what we can do. But what we can do is to seek to minimize our partiality, our lack of knowledge, our lack of understanding, and our judicial education programs can help us achieve that goal. Thirdly, does appointment to the bench mean leaving behind personal, professional, moral, or political identity? The answer is, in my view, absolutely not. Rather, it means integrating these aspects of ourselves into a larger vision of one's ethical identity as a judge. And what about Justice Sotomayor? Why did this cause such a concern? It raises a concern because many commentators have, quite frankly, a mythological understanding of judicial ethics. It denies both the reality and the vitality of identity and experience. Identity and experience are goods, not bads. Finally, can judicial ethics be taught? And I guess my answer to that is, I hope so. If not, I've wasted 20 years of my life. Thank you very much.
All right, no PowerPoint for me. Mostly because I just wrote my talk a second ago. No, actually, that was the purpose of this. And in fact, thank you to Paul and to McGeorge and to the Pacific Center for inviting me here as a commentator. This has been great for me as a chance to think about judicial ethics theory and legal ethics theory, which is what I do, in a somewhat more comprehensive way. I'm about to assume a role of an imposter and talk about social science, about which I know nothing. As well as being a lawyer, my graduate training is in moral and political philosophy and jurisprudence. And I tend to approach judicial ethics from the point of view of asking questions about what impartiality means and what sorts of considerations can be taken into account by judges, especially considering the kind of fundamental framing in terms of both independence and accountability as being fundamental values in judging. It's interesting to try to unify those two things. How can judges be independent but also, politically accountable in some way? So I actually tend to, in my work, engage with a lot of the stuff that Richard does, and I could have a long and hopefully fruitful discussion with Richard about some of the points that he raised in his paper. But I actually want to talk a little bit more about Judge Irwin's paper and talk a little bit more about behavioral psychology. As I've been teaching legal ethics over the years and doing work in philosophy, I can't help noticing the accumulating body of research in the behavioral social sciences about how we make decisions. And it helps that I have a lot of colleagues on my faculty, many of whom should have been invited in my place, who talk about this stuff. I have a colleague who's got a PhD in cognitive psychology who talks about the way in which human decision-making is predictably and systematically skewed in very interesting ways, which make it difficult to think about responding to unethical behavior in sort of traditional ways. So I want to finish this talk by talking about some of the ways we normally think about dealing with unethical behavior, and then show ways in which the findings of behavioral psychology kind of problematize that a little bit. Now, normally the social psychology research that we're drawing from here starts from a baseline of a kind of correct decision, and it's easy to show the deviation from the right decision. So, sort of famous example that's in the literature, Daniel Kahneman, who won the Nobel Prize in economics recently for this research, ran a famous experiment in which he asked people gave people the following scenario. He said, Linda is a 31-year-old woman. She's single. She's very smart. She majored in philosophy. She's concerned with inequality and social justice, and in college she participated in anti-nuclear demonstrations. Which of the following is the most likely? A, Linda is a bank teller. B, Linda is a bank teller and involved in the feminist movement. Interestingly, 85% of respondents to this question chose B, that it's more likely that Linda is a bank teller who is active in the feminist movement. Now, just a moment's reflection will show you that as a matter of probability theory, that can't be the right answer. It can't be more likely that two things are true of one person than one thing is true of one person. And so, Kahneman is able to show, using this and many, many, many other examples, that people predictably deviate from the right answer in their decision-making processes. Now, it's easy in a case like Linda, the feminist bank teller, because you have an obvious right answer. You you can show upon reflection that the right answer has to be that it's more likely that she's a bank teller than that she's a feminist bank teller. The trouble with applying this to judicial ethics, of course, is that it tends to presuppose all of the hard questions. We need to figure out what the right decision is, and that's what Richard's work on impartiality and objectivity is really all about. So I recognize that this is difficult, and a comprehensive theory of judicial ethics has to engage with the question of objectivity first before we can start talking about deviations from objectivity. But I want to bracket that for the purpose of this talk. I want to assume for the sake of argument, and we can reopen the argument later, but I want to assume for the sake of argument that there is a right decision, or at least a range of reasonable decisions that a judge can make in a particular case. There is at least a set of cases that some suitably defined, objective, impartial observer would agree are the right outcomes of the case or defensible outcomes of the case. And I then want to ask why it is that judges might deviate from that. And what I really want to question is the kind of standard account of this. So when you think about cases like Caperton, right, the case that went up to the U.S. Supreme Court, where Don Blankenship, who's in the news again for mine safety violations, when he basically bought a judge of the West Virginia Supreme Court, why do we worry about this? Or why do we worry that Justice Scalia goes duck hunting with Dick Cheney when there's a case involving Cheney's Energy Task Force pending before the Supreme Court? The sort of standard the standard answer to this posits that judges will somehow consciously favor their buddies or throw the case to their friends out of reasons of sentiment or gratitude for the campaign contributions or something like that. But I want to problematize that account a little bit, and I want to suggest that the way in which judicial corruption works is quite a bit more complicated than that. And so the response can't be simply instructing judges to remain impartial or telling them to put their feelings aside or whatever, because the reasons that judicial decision-making gets skewed are related to the reasons that any human decision-making gets skewed. It's complicated. And the foundation of the story in the behavioral psychology literature starts with so-called dual process models of decision-making or judgment, which posit that actually decisions that we make have two components. They're the product of two different systems that run independently but in parallel, and these are called in the literature System 1 and System 2. I'm not very helpful and descriptive, I know. But the idea is that System 1 is a kind of intuitive, quick, unconscious approach that kind of operates without our acknowledging it or recognizing it. Those of you who have read the popular book by Malcolm Gladwell, Blink, know that this is all about System 1 processing, that Blink is all about intuitive judgments that we all make without really being aware of what we're doing. And there's a lot of interesting research on this that shows the effect of System 1 processing. There's a great study that correlates stock market returns to the weather. Apparently, when people are in a good mood, they become optimistic and they invest. And so market returns, fluctuate according to the weather. And I think in response to that, all stockbrokers should relocate to upstate New York, because then they would all be suitably pessimistic and cautious with their clients' money. But there are all sorts of predictable System 1 errors that cause people to begin the reasoning process without even realizing it, kind of off a little bit. The implicit association stuff that Professor Banerjee does is a good example of this. It is one of many predictable System 1 errors. Implicit association tends to get us thinking about an association between two things without us realizing that we're doing it. Other examples of System 1 errors include things like the representative heuristic. Why do people think it's more likely that Linda is a feminist bank teller than a bank teller? Because the description is representative of a type that we think goes along with the description feminist bank teller. So we tend to rely on that image that we have in making decisions and don't realize that we've made a mistake in our math. There are all sorts of things like this, but what they do, the critical thing about this is that System 1 starts the reasoning process, which then gets picked up by System 2. And System 2 is just the word for a more conscious, reflective, thought-out, principled, top-down kind of reasoning process that we normally think is constitutive of judicial decision-making or ethical reasoning. When we think about judicial reasoning or lawyerly reasoning or ethical reasoning, we implicitly have in mind System 2. We think it's deliberative, conscious, reflective. And it is. But the trouble is, it starts out framed in particular ways by intuitive, unconscious judgments. Not just implicit association stuff, but all sorts of implicit judgments that tend to start the reasoning process off in one direction or another. And the general term in the social psychology literature is framing. There's a framing of a decision-making process that tends to make certain considerations salient and certain considerations not so important. It tends to identify the situation in a particular way. This is an ethical dilemma. This is not an ethical dilemma. It tends to attach certain kinds of values to decisions. This is a risk, this is a loss, this is a potential gain. It does things that start off the conscious decision-making process in a particular way without our knowing about it. So playing on conscious decision-making factors only works to correct errors in reasoning if we are attentive to the way in which unconscious decision-making factors start the system off in some particular direction or another. Now, the problem is, of course, that these two systems are dynamic and they interact. And there are ways in which errors in System 2 or more deliberative processing can exacerbate problems that arose out of implicit unconscious decisions. There are problems like confirmation bias, for example. This is a very robust finding of social psychology that suggests that the way people confirm something they believe to be true is to look around and find confirming incidents. They don't actually try to find disconfirming incidents. And so they pick out examples that confirm what they already believe, and they say, hey, look, the data confirm my belief. When in fact they haven't been rigorous about it and therefore miss instances that would have disconfirmed their belief. So there are problems in System 2 reasoning as well that tend to entrench System 1 errors. And there are some really great accounts of organizational decision-making fiascos. There's a guy at Princeton called John Darley who writes really well about contagious organizational corruption. And the full causal account of these problems relies on the interaction between unconscious, affective, automatic System 1 decisions and conscious deliberative decisions in System 2. And a full causal account of something like the concern in the duck hunting case or the concern in Caperton would show how these processes work together. Now, the little time flag just went up, so I just wanted to point out that when we think about judicial ethics and judicial regulation, we have to be attentive to the way judgment and decision-making actually works for real people in the real world. And that might make us skeptical of the sorts of solutions that are typically proposed to deal with corruption or partiality or whatever, such as, for example, making education better. Education is great, I'm an educator, but it works on System 2 processes. It makes people better at doing conscious, top-down, principled, reflective decision-making. It doesn't really address the sorts of things that Judge Irwin is talking about here, automatic, intuitive errors. Similarly, codes of conduct. People respond to codes of conduct, of course, but that depends on their perception that they are in an ethically or regulatorily problematic situation. The situation has to have been framed already as one calling for the exercise of ethical judgment or response to a code of conduct. And if the decision is framed unconsciously in a way that suggests there isn't a problem here, then codes of conduct aren't going to really address the problem. And the same is true about reliance on character, self-restraint, virtues, or things like that. You will see if you almost draw cases at random in the U.S. Jurisprudence of judicial ethics, you'll see cases that say things like the following. The presumption is that a judge will put personal beliefs aside and rule according to the laws as enacted, as required by his or her oath. Courts do that and then go on to say, there's no problem here. But the trouble with that, of course, is that this presumption turns out not to be true. People aren't very good at putting aside personal beliefs. Moreover, people are overconfident in their ability to do that. Another very robust finding of social psychology is that people overestimate their ability to do all sorts of things that are coded as good. So if you ask people, are you a good driver, 85% will say above average. That can't be right. But people tend to systematically overestimate their ability to do things and then ignore this kind of thing and say, I've already put aside personal bias. This isn't really about me. I'm fine. I'm a good, virtuous judge. And again, this doesn't show that that particular judge is a bad person or this person is corrupt. It's simply a feature of human decision-making. Judges, I know they occupy an exalted place, and they have black robes and all that. And I call them Judge. I call everyone by their first name, but I call Judge Irwin Judge Irwin. We respect judges. We believe that they're very good at doing what they're doing, but they're people too, right? And they're people susceptible to the same kinds of totally systematic, understandable, general problems in cognition that all of us have. And so my only suggestion here is when we think about the responses to the problems that we're concerned with, let's think about it in terms of the findings of psychologists who think about the way people make decisions, because we'll simply do better at it. Whatever we do, we'll do better by being aware of of what we know about the way people make decisions. Thanks.
I promised an interesting and provocative start, and I don't think we've been disappointed. What I want to do in the time that remains before we head to the coffee break is actually get the discussion going a little deeper and bring some of these ideas together, be thinking about the questions you want to pose, but I actually want to start off with a couple that I'll ask all three of you to address, because one of the things that struck me as we got into the development of the papers and the panel and the ideas, and for me, again, the Canada-US divide, is that it's critically important when you look at a US system where judges are elected as opposed to being appointed, that these conceptions become that much more critical and difficult when you think about democratic deficits. Because one of the things that I grapple with, particularly in looking at Richard's discussion of sort of substantive versus formal equality, is what do we look at judges to do? And what we expect of judges will therefore temper our responses to all of you, because Judge Irwin, with all due respect, in terms of looking at implicit bias, some of my friends on the right would say, well, so what? It's about the formal application, as Brad's gone back to the quotation and the variations of it. You're supposed to actually judge on the law, and if you're elected, we're electing you to represent us in terms of your understanding of the law and what we believe you will do. The difficulty that I think comes up from some of these perspectives, as we look at elections and talk, leading into the next panel a little bit, is the conception that, well, a judge is supposed to actually be a representative of us rather than a kind of fiduciary to the system. And I think we'll see that in a newspaper story this morning about the confirmation fight over Godwin Liu, professor at Berkeley, aligned very much with particular movements, involved in the ACLU, as another indication of this problem. So what, long introduction, professors are known for doing that, to a fairly simple question in terms of coming back to this implicit bias issue, and Richard, to you on sort of substantive versus formal equality, which I think is tied to it. What do we do with that? What do we do with that in a system where judges are and can be elected? Judge Irwin, let me start with you. I mean, you've identified the problem, and so you've asked judges to think about, and we've asked all of us to think about our own sense of objectivity. But what do we do about it in terms of a system that we've got as it's structured currently?
Two or three thoughts.
Let me just actually invite you to go closer to the mic.
You got it. Two or three thoughts. Can you hear me? The first is the notion that was perpetuated by Chief Justice Roberts. That is the notion that we just call balls and strikes. It's the notion that law is black and white. Law is not black and white. We could have, computers do it if it was. So that's one of my premises. Going to the election question, first of all, I think there's a bit of a myth about judges being elected. Just given my experience the last 10 years being involved with the National Council, I don't have the data, but I would hazard to guess that the majority of judges who are elected were first appointed. What happened is the culture is in an elected environment, by and large, is you leave office. When you're going to retire or go do something else, you don't serve out your term. You wait until there's the appropriate political climate. You leave, the governor or whomever is the appointing power appoints. Then that person stands for election at some point, but they've already become an incumbent. I think that's something to remember too. Elections are really a little bit more nuanced, I think, than we're led to believe. And the last thought I have, or premise I have that I'm thinking about as you spoke, is this notion of judges vis-a-vis elections, judges being representative of people somehow versus some type of neutral arbiter. We were talking about this at dinner last night, and the concept of elections is flawed, I think, to the extent that the public does not understand the role of the judiciary. I don't mean to impugn the public, but the education has not been, the information has not been put out there that we do not get elected because we have agendas that represent your particular set of beliefs. We are elected because of our ability to decide cases based on law, to interpret law, to read law, to study law, to be thoughtful. So to the extent that you believe that that's what judges should be doing as opposed to running on agendas, I see that just as a really important thought to keep in mind, and I'll leave it at that for right now.
Richard, to you in terms of the bias and in particular your focus on the substantive versus the formal equality point. I mean, what are we supposed to do with that? Once we've identified the bias, we engage in this social context education, or as certain friends of mine up in Canada would call it, judicial re-education camps, as they're criticized very, very heavily. What do we do with it? And I'm delighted that you're teaching in judicial re-education camps, but others might be upset because they don't share your particular view of our constitutional tradition.
Sure. A couple of quick points. It is fair enough to perhaps describe these as judicial re-education camps, but you should know that they're taught at the finest hotels in Canada. And we don't have a problem of getting judges to voluntarily come to them. So I guess that's the first point. Second point is, I do want to say something about the elected-appointed distinction, first of all. Like John, I'm not going to call him Judge Irwin because I'm Canadian and therefore less respectful than Brad is, right? Or maybe it's because I'm Irish. I'm not sure which it is. It's the Irish bit, right? So, it's true that we have an appointed judiciary. However, it's still decidedly politicized as a process. And that's becoming increasingly apparent under our current Conservative government in Canada. So the idea that elected is sort of somehow problematic and appointed is less problematic, I think is a problematic dichotomy. I think John agrees with this. It's more of a spectrum than it is a polarity. So I do want to challenge that because I do think that our current process is deeply problematic in Canada. And we might be able to make it better in certain ways, but it still always has been, and I think, frankly, should always have a political dimension to the appointment of judges. And I've talked about it at length in other papers. To go to the second point, formal versus substantive equality. I guess what I want to say on that is the reason why this is important is because judicial judgment is an act of local knowledge. Judges are not oracles who have access to natural law in some universal sense. All law is local knowledge. It's a local practice. And so the culture of the United States is clearly somewhat distinct from the culture of Canada. We have made it a decision in Canada through government, but also through the judiciary, to go more towards an equality principle than a liberty principle. And I see liberty and equality as, in a sense, being two sides of the one coin. The coin is sometimes sort of more heavily weighted on one side rather than the other. But you actually can't have liberty without some real attempt at substantive equality. And our courts have started to identify and recognize that to some degree. And I think this is important because I want to take us back to the idea of having an ethical identity. It seems to me that when we say that judges are simply meant to be there to, what's the baseball metaphor you used? Balls and strikes, right? I think that's the mythology, right? I think it is really underplaying the challenges of being a judge, which is, as I've already said, this sort of exercise in local knowledge. And I think if you get judges to think about having not just this role morality of the impartial umpire who calls it, but actually they see themselves as a true judgment maker in a thick sense and not in this sort of thin formalistic sense. It sort of helps us, and I'll phrase it this way. I think the classical idea of the neutral umpire sort of helps judges sleep at nights. I think the idea of having an athletic identity keeps judges awake at nights. It makes them uncomfortable in their role and in their capacity for judgment. And the final point I'd like to recommend here is Justice Albie Sachs, formerly of the Constitutional Court of South Africa, has written a spectacular book recently called The Alchemy of Life and Law. And I think those words, life and law. The model that's described as the classical model is just the alchemy of law. Forget the life part of the equation. What Albie Sachs brings to the project is bringing those two together. And so judgment is this exercise, this alchemy of life and law, of the personal and the professional. And it seems to me that good judges are the judges who stay awake at night and worry about those things, which is why I think John needed to have his book to help him sleep last night.
Thanks, Richard. Actually, it's interesting, the reference to Judge Sachs. We were privileged to have Judge Richard Goldstone with us a couple of weeks ago, talking very personally about his experience in life and in law in that exact regard. Brad, to you, in terms of some of these issues, and in particular, as Richard mentioned, your concept for lawyers of fidelity to law, because I think that foundation, that conception of arising out of your commentaries on the lawyers involved in the torture memos, the questions apply to all lawyers, but also to judges. You know, do we expect then that similar fidelity of judges to the law? Is it sort of a fiduciary trust that we impose on them?
Well, thanks, Paul, for giving me a chance to plug my book, Lawyers and Fidelity to Law, which is coming out this summer. So everyone go rush out to Amazon and buy it. But no, that goes back to the question that I bracketed earlier, which is actually more my comfort zone as opposed to the behavioral psych stuff. I think about this from the standpoint of jurisprudence. And this is the hard question, right? But it's for me, the interesting question. So let's take Richard's example of equality, or formal versus substantive equality, or equality of outcomes versus equality of opportunities, or whatever. These are both different conceptions of the idea of equality. Lots and lots of cases in the U.S., in particular on things like affirmative action, play on which of these two conceptions of equality is the operative one. And the independence accountability problem goes like this. You can imagine that equality can mean either formal or substantive equality, equality of outcomes, equality of opportunities. That could be, either one of those could be a reasonable interpretation of the idea of equality. Now, who gets to decide? Well, in our system, judges get to decide, but the democratic deficit problem is when you imagine people going, hey, how come you get to make that decision? Both of those conceptions of equality are potentially apt descriptions of the political value in question. How come you, dude in the black robe or woman in the black robe, gets to make that decision and not me? And answering that question, I think, is the big fundamental task of academic jurisprudence. And people who write in this area try to give some account of why judges ought to get to make that decision and not elected legislators. There are answers like Ronald Dworkin talks about judging as the forum of principle, and talks about judges as being able to recover underlying political principles. Cass Sunstein talks about political reasoning as being the skill that lawyers and judges learn. It's a kind of differentiated virtue that lawyers have, and they can therefore reason by analogy and make incremental decisions and all that. Whatever. I mean, I don't want to take a position on that right now. The point is, that's why academic jurisprudence exists. It's trying to figure out why it is that judges get to make decisions like that and not elected officials, not people acting through their elected officials. So to the extent I do see this as a fiduciary responsibility that judges have, fiduciary obligation toward the law, I do want to acknowledge there's a democratic deficit problem there. So when I say judges have an obligation to make decisions that are defensible under law, I recognize that law doesn't create, as Dworkin says, one right answer. There's not one right answer to every case. There may be a range of right answers, and the accountability problem comes in where a judge is selecting one from many eligible right answers and then trying to defend that as the right answer as against a demand for justification from citizens. So I think that's a really important question.
Go back to Judge Irwin for a brief response, and then I've got time for a couple of questions.
Two quick thoughts, and I guess I want to get a little bit more down in the weeds, and I only have questions to pose, not answers to give. Keep in mind that trial judges and appellate judges function very differently, and I just bring that up in light of the fact that the book Blink was mentioned. And I thought of an article, I'm guessing I probably plagiarized this somewhere, an article, Blinking versus Staring. I mean, when you think of what trial judges do, very fast decision making, and those dynamics of level 1, level 2, conscious, unconscious, play out, I would say, very differently, or possibly very differently than appellate judges. I see Justice Roby over here of the California Court of Appeals. He knows of what I speak. We will sit there and spend days with our clerks going over one ruling from the bench. Very different kind of decision making. Does one lend itself better or worse to the kind of decision making we strive for? I don't know the answer to that. Maybe like most things in life, it's a little bit of both. Who knows? And the last thing I would mention is my experience as a judge. I've been a judge for 18 years, lawyer for 33. And what made me think of it is calling me judge. The judges are very, our lives are altered by being judges. Not in a sympathetic sort of way, but like people calling you judge. I submit that it does change your view of the world. You are isolated, and that isolation, I don't think, works towards the things that I was talking about or Richard and Brad are talking about. So maybe we need to think that as well, the world that judges live in.
Thank you. Professor Cravens.
This question is for any or all of you, whoever wants to tackle it. There's pretty prevalent use of appearance analysis, appearance of impropriety, or appearance of bias. Sometimes that's a matter of face saving. Sometimes it's a matter of being willing to overcorrect, just to be careful for whatever underlying value that might support. The question is this: do appearance standards in this conduct analysis help or only confuse the matter when it comes to implicit bias? Is that a good sort of corrective for implicit bias, or is it just further complicating the problem? And if it is, how would we better integrate it?
Were you all able to hear the question? Okay. To the panel. Appearance standards. Appearance of impropriety. Never mind just the impropriety.
I'm happy to have a first shot at it. I guess it's a great question. So appearance standards always say appearance in whose eyes? And the answer always is in the eyes of the reasonable. Used to be the reasonable man, right? Now we've got the reasonable person, right? But what I'd want to argue is, well, if we live in a world as diverse as I think we do live in, right, there is no such thing as the reasonable person, right? And the appearance in the eyes of, for example, in Canada, the Aboriginal community, or the black community in Canada, or the Muslim community in Canada, is probably not the appearance that I see as a fairly well-located white male. And it seems to me that the appearance standard is itself part of the problem. It's not necessarily part of the solution. So what we need to start asking then is not so much what's the appearance issue here, is what are some of the deeper values that are at stake? And Brad's talking about this. Is it liberty? Is it equality? Is it sort of individual rights? Is it a larger collective good? And so I think the appearance discourse is a shorthand way of avoiding the hard debates we should be actually having.
Yeah, I run around making myself a nuisance at judicial ethics events, railing against the appearance of impropriety standard. I think it's just, at best a make-weight, and at worst a distraction. The standard has to be fleshed out in terms of how would this appear to a reasonably well-informed outside observer. Otherwise, it credits all of this wackos who think that judges are being controlled by rays being beamed at them from the CIA or whatever. So I mean, you've got to discount that. So you've got to say, what would a reasonable person think, and what would a reasonable person think tends to reduce to, was the decision right or not? I don't see why you don't just focus on whether the decision was right or not, whether it appears to be right or not. I think that doesn't add anything. I know it's traditional. I know it's got a long history. I know the common law standards go way back talking about appearance of impropriety. I just think it's a distraction and could be eliminated without any cost.
And again, from a more practical standpoint, when I was chair of the Judicial Advisory Committee, judges write in, is this ethical, not ethical, what are my problems? The appearance of impropriety, we always came back to that. And there's so much wiggle room, it might as well not exist. And I think it just drives home the point that Richard is making about what you want is to change judges or to improve judges' values or the way they look at how they determine what is right and wrong, not externally but internally.
I'm conscious of making the trains run on time, and I've got a couple of speakers' questions to go, so let me go to them and then we'll break for coffee, so I'll extend the session by another 5 minutes. Professor Walt.
I wonder, thank you for a fascinating presentation. I wonder if maybe one would walk away thinking that even if we are right that implicit bias is common, I suggest perhaps as a devil's advocate, perhaps we should do absolutely nothing about it. And here's why. And because I'm a law professor, I tend to think in hypotheticals, so here's a very quick hypothetical. A defendant commits a crime on the street. The defendant, according to this, will be himself or herself motivated by, and in part to make decisions that are biased. The victim will perceive the perpetrator with impartial bias. The witnesses will be influenced by bias. The investigating police will investigate with implicit bias. The case will be brought with implicit bias. The case will be defended, and the theory of the defense counsel will be implemented with implicit bias. And it seems to me that if we now come before perhaps a jury, the jury would likely be impacted by implicit bias. So is its decision really to try to fix judges? So assuming that implicit bias quite seriously impacts how we all operate, every aspect of the problem and the operation of the trial, the court system and how the trial will take, everything will be tainted by this implicit bias, and the solution should be to try to make judges be outliers and in some way be less biased than everybody else. It just seems that perhaps the problem is so severe and so all-consuming that solutions ought to be quite cautious before we move and implement them. I just wonder.
Well, I think there are ways in which that manifests itself that are specific to each one of those actors. So you talk about police and court clerks and judges and jurors and lawyers and whatever, and each one of them may have particular problems. My colleague, Jeffrey Klinsky, who studies this stuff, goes around to judicial training conferences and runs experiments on judges. It's his own lab rats. It's pretty cool. And he demonstrates that judges err systematically in their ability to do things like ignore inadmissible evidence. In ways that cognitive psychology would predict. If that's true, there may be ways that are specific to judges to prevent that problem from affecting decisions. There may be just different doctrines of evidence or things like that could be used. Understanding that people are affected by implicit bias in certain ways. So, yeah, of course, it's too much to say we should all stop being irrational. We're all irrational in interesting, predictable ways. We can't all stop being irrational. But there may be some kind of relatively uncomplicated institutional reform that could reduce the effects of these irrationalities in certain contexts. And if it's possible to do that by, simply fiddling with evidence law in some way, then why not do that?
I take your point that sort of issues of bias are systemic and structural, but I guess I'd flip it back to you as a university professor. It seems to me that you're counseling the role of what I would call democratic irresponsibility behavior. In fact, I would say that you're actually not living up to your obligations as a university professor by making that suggestion. We have obligations as members of the polity to try to intervene where we can. So while we may not be able to solve all the problems of the world, we have a particular responsibility as university law professors to think about making the interventions where we can. So I know I'm ramping up the stakes here, right? But you like hypotheticals? I've given you a counter argument.
Okay, time for one more, Jim.
And I know you're trying to get the train run on time, so this is as much a comment maybe as a question. I'm not sure how much response there'll be, but I was curious if it really brought home for me as we were talking both about selection of judges and implicit bias, that it really kind of merged together in my mind to highlight the fact that there's another layer to this whole problem, right? And that is that the selectors, whether they happen to be the electorate, whether they happen to be a legislature, whoever they happen to be, may be good or bad at this, but they are probably trying to select judges who share their implicit biases, yeah? And so it's not only a problem of judges having implicit biases and what can we do about it, or other things we can do that would ameliorate the effects of them, which I agree we should try to if we can. But it just occurred to me as I was listening to your comments and your remarks that merge these two things, that whatever the selection process, we probably select judges by virtue of what the prediction of their implicit biases might be.
I understand, actually, in that respect, there's supposed to be a press conference in the White House lawn this afternoon. We may get an opportunity to test out sooner rather than later what some of those things are. And with that, I'm actually going to call the session to a close. Please join me in thanking our panel for a provocative start to the day.
Thank you. Thanks. Thank you talking about
Two brief administrative announcements. We will post Professor Devlin's PowerPoint presentations up on the website, so you can access those afterwards. Please reconvene for 11 o'clock in this room, and we'll start the second panel.